Hi everyone, welcome to Chandan Logics. This is your Narsimha Kasaram. Today we are going to have a session on polity. So we are going to discuss different topics, different articles, various provisions under polity, right? So here we go. Very good evening, Likita, Anu, Bujama. Very good evening, Amma. Yeah, before I start, RRB ALP 2025 ki CBT1, CBT2 batch course available undi. So special batch undi ikkada manaku total 9,900 plus vacancies unnai and 6 months and 12 months duration tho manaku course available lo undi anamata ikkada. Okay? And ఇక ఆర్బీ గ్రూప్ డి 2025 కోసము స్పెషల్ బ్యాచ్ ఉంది 32,430 ప్లస్ వ్యాకెన్సీస్ మనకు ఉన్నాయి దీనికి. సో దాన్ని దృష్టిలో పెట్టుకొని 3 and 6 months డ్యూరేషన్తో మన కోర్సెస్ అవైలబుల్లో ఉన్నాయి. ఇది కూడా మనకి ఇంగ్లీష్ అండ్ తెలుగు మీడియం రెండిట్లో అవైలబుల్లో ఉంది. అండ్ అదేవిధంగా ఆర్బీ ఎన్టీపీసీ విషయానికి వచ్చేసరికి ఇక్కడ కూడా మనకు స్పెషల్ బ్యాచ్ ఉంది ఫర్ CBT1, CBT2 కంప్లీట్ కోర్స్ అవైలబుల్లో ఉంది. అండ్ ఇది కూడా ఇంగ్లీష్ అండ్ తెలుగు మీడియం రెండిట్లో అవైలబుల్ ఉంది. ఈ నెంబర్ కాంటాక్ట్ అయితే దే హెల్ప్ యూ ఇన్ పర్చేసింగ్ ద కోర్స్. అండ్ ఇక్కడ SSC ఎగ్జామినేషన్ 2025 స్పెషల్ బ్యాచ్ ఉంది ఫర్ కంప్లీట్ కోర్స్ 50 ప్లస్ వీడియో లెక్చర్స్ అవైలబుల్లో ఉంటాయి. 3, 6 and 12 months డ్యూరేషన్తో అవైలబుల్ ఉంది. ఇది కూడా మనకి ఇంగ్లీష్ అండ్ తెలుగు మీడియం రెండిట్లో అవైలబుల్లో ఉంది. ఓకే. అండ్ 0 to Hero స్పెషల్ బ్యాచ్ ఉంది బై అర్థమెటిక్, రీజనింగ్ అండ్ అడ్వాన్స్ మ్యాథ్స్ ఇక్కడ అవైలబుల్ ఉంటాయి ప్రిలిమ్స్ అండ్ మెయిన్స్ దృష్టిలో పెట్టుకొని. ఇది కూడా మనకు 3, 6 and 12 months డ్యూరేషన్స్తో అవైలబుల్ ఉంది. 1 month డ్యూరేషన్తో అవైలబుల్ ఉంది. ఓకే. హియర్ వి గో. ఫస్ట్ క్వశ్చన్ ఆఫ్ ద డే. వెరీ గుడ్ ఈవినింగ్ రిషిత, మిస్టర్ Nikki. వెరీ గుడ్ ఈవినింగ్. The protection of interest of the minorities under the Constitution of India lies under. Okay. So here if you see that they are asking that under which article the minorities' interests are protected. So which article will protect the interests of the minorities? Because there are two types of minorities. Religious minorities are there, linguistic minorities are also there. Right? So to protect the interests of the minorities are allowed to run their own education institutions, okay? And minorities are also allowed to have their language, okay, their medium of instruction in their own mother tongue also. So this kind of provisions are available under which article is the question. Now we have got Article 20, Article 16, Article 15, Article 29. What is the right answer for this question? Guys, quick. Yes. What is the answer for this question? Question number 1 is before you. You may answer this question. Right, first question is, first answer is given by Anu here. Anu goes with option D. What about others, guys? Okay, Rishita is going with also option D only. So most of you are going with option D. The right answer is nothing but option D, Article 29 is the right answer. Okay, so Article 29 is the right answer. Article 29 protects the interests of the minorities, right? Now if you see that here Article 20 speaks about the protection against conviction, okay? Means except by the law, other peoples cannot convict a person. So protection against conviction is provided by the Article 20, and a person cannot be convicted twice for the same mistake that he has done. Means for the same wrong thing, a person cannot be punished twice. All these are present in Article 20. And when you come to Article 16, it speaks about equality of opportunities, equality in providing opportunities. And Article 15 speaks about elimination of the discrimination when accessing the public places, right? So there you can have Article 15. So these are very important articles. We look into details. The first and the foremost, the answer is nothing but Article 29, right? So what is the Article 29 saying here? Article 29 is saying that it protects the interest of the minorities by making special provisions for them, okay? Special provisions, how to protect their distinct language, their script, their culture. So everyone has the right to protect their culture. The majority culture cannot be imposed on the minority. Majority language cannot be imposed on the minority. That is the reason if you see that Hindi is not the national language. Hindi is not the national language. Hindi cannot be imposed on other people who are speaking different other languages. Right? So there is also, for example, you go to a place called Karnataka. In Karnataka, there is a district called Ballari district. Now when you go to Ballari district, there are people who are actually speaking in Telugu. Their mother tongue is Telugu. That is the reason in the state of Karnataka, in the Ballari district, you also have Telugu medium schools. Why Karnataka state is having Telugu medium schools? Protection of the interest of the minorities. Here what kind of minorities? Linguistic minorities. Okay, so that is how Article 29 plays a very important role. So Article 29 mandates that no discrimination would be done on the grounds of the religion, race, caste, language or any one of them. Okay, and the protection of the minorities, linguistic minorities, their culture, okay, their script, everything has to be protected. So we'll take care of this, state will take care of this. And coming to Article 20, protection in respect of conviction for offences. So when the person does a mistake, okay, since the person has done a mistake, all kinds of atrocities cannot be imposed on that person. Okay, you cannot punish the person twice for the same offence. This is also not right. Okay, so to protect such convicts, we have got Article 20. So if we look into Article 20, no person shall be convicted on any offence except for violation of the law. So if a person is not violated by the law, you cannot punish that person. Only when the person is violated the law, through law you can punish that person. Okay, and not be subjected to a penalty greater than which might have been inflicted under the law in force at the time of the conviction. Okay, so when the person has committed a crime, there will be certain amount of penalty to be imposed. Now you cannot impose a penalty more than that what is actually prescribed. For example, today I committed a crime. At this point of the day, for committing this kind of crime, this is the penalty. Tomorrow if we change the penalty, you cannot impose the same penalty on me. What should be imposed on me? When I committed the crime, what was the penalties? The same penalty should be imposed. For example, let us say that I jumped a traffic signal. I jumped a traffic signal, say on this particular day. Let's say today is, what is that, 17th? I think today is 16th, right? On 16th April, let's say I jumped a traffic signal. And let's say the penalty is what, 500 rupees. What is the penalty? 500 rupees. Okay. Maybe from tomorrow government made a rule saying that the penalty for jumping the traffic signal is, let us say, 1000 rupees. Okay. And tomorrow what they did, they saw the CC cameras and they found that I jumped the traffic signal on 16th of April. But on 16th of April, what is the penalty? The penalty was 500 only. So they cannot impose on me 1000 rupees. They should impose only 500. Since the rules have changed now, they cannot impose this 1000 rupees for a mistake I have committed when the penalty was 500. So all this protection comes under Article 20. Very, 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 very important. Okay. And Article 20 also says that no person shall be prosecuted or punished for the same offence more than once. I committed one mistake, I should be punished only once. You cannot punish me twice for the same mistake. You cannot punish me twice for the same mistake. Okay. No person accused of any offence shall be compelled to be a witness against himself. So for example, I committed a mistake. And in the court, they cannot punish me based on my version. Okay, based on my version, they cannot punish me. They should find some other witnesses, and if those witnesses says that yes, this person has done mistake, they can consider. But I cannot be a witness for my own crime. I cannot be a witness for my own crime. Why this provision is kept? Because when a person is powerful, they will try to influence these fellows, and they will tell that you agree for the mistake on yourself. Okay, so to prevent that, they are saying that a person cannot be a witness of himself. So Article 20 is very, very important. Okay, you cannot impose a penalty more than the amount that was existing when I committed a crime. Second thing, I cannot be punished twice for the same conviction or for the same mistake. Third thing, I cannot be a witness of my own offence. So these three are very, very important under Article 20. Is that clear? Yes? Very good, very of you. Okay. Yeah. Next one, Article 16, equality of opportunity in the matters of public employment. So they are saying that when you are aspiring for a public employment, for a public or you can say for a government job, everyone will have equal opportunities, but some exemptions. Like if you are from a backward caste, if you are from a economically backward, if you are from a scheduled caste, scheduled tribes, there will be some exemptions. Exemptions will be there. But generally, if not exemptions, you cannot treat persons based on from where are you coming from, so what is your mother tongue, based on that you cannot treat differently. So that's what it says. There shall be equality of opportunity for all citizens in the matters relating to employment or appointment to any office under the state. So that is nothing but Article 16. But remember that Article 15 will have some exemptions. Article 16 also will have some exemptions. Based on that exemptions only, we have got the reservation phenomenon. Right? Why do we have reservation for SC, ST, BC and economically backward caste? Based on the exemptions mentioned in Article 15 and Article 16. Okay. What does Article 15 says? Prohibition of discrimination on the grounds of religion, race, caste, sex, place of birth. So, based on the religion, you cannot discriminate a person. Based on the sex, you cannot discriminate a person. Based on the place of the birth, you cannot discriminate a person. Okay? Great people or powerful people are born in the powerful places. So, when the person comes from a powerful place, you should not treat him separately. Okay? So, that is prohibited under Article 15. Okay? Like that, even based on the caste also, you cannot treat a person differently. Got it? So, this is Article 15. So, very, very important, all these articles. Article 15, Article 16, Article 20, Article 29. Okay? The next question is here. The union list, state list and the concurrent list included in which schedule of the Indian Constitution? Okay? So, this is something like, division of powers. So, central government has got certain powers, state governments has got certain powers. There are some powers which are held both by the center and the state. Now, all these are mentioned in the which schedule is the question. Is it mentioned in the 7th schedule or 10th schedule or 12th schedule or the 8th schedule? What is the answer for this question? Yes, right to live, Article 21. Lokesh, you are exactly right, Amma. Yes. Article 16, Clause 4, EWS, that's right. Yes, super, excellent. The right answer is mathematics 7th schedule. Okay, 7th schedule speaks about the division of the powers between the center and the state. Okay, so what are the areas where central government has got a power? What are the areas where the state government has a power? There are some areas both central and state government has a power. For example, if you see that when you speak to a bill called GST bill, right? GST is a special constitution amendment bill with ratification of the states. Why ratification of the states was required in the GST bill? Because GST or taxation comes under a concurrent list. It comes under the concurrent list where central government and state government, both of them have got the powers. So, under the 7th schedule, taxation system comes under the concurrent list where central government and state government, both of them have got the powers. So, when you are making amendment to the constitution with respect to the taxation, not only the parliament should agree, along with the parliament special majority, more than 50% of the states also should agree. The reason is that taxation comes under the concurrent list. So, that is the specialty of the 7th schedule. Okay. The 7th schedule of the Indian Constitution deals with the division of powers between the union government and the state government. Article 246 deals with 7th schedule of the Indian Constitution. What is the article? Article 246. And what are the different types of lists? We have got a union list, we have got a state list, and we also got concurrent list. Those lists which are not part of these three will be part of the reserve list. This will be again exercised by the central government. Okay. There are 100 subjects on the union list, 61 subjects on the state list and 50 subjects on the concurrent list. They will keep on changing whenever some amendments are done. Okay. Indira Gandhi, when she made the 42nd Constitution Amendment Bill, some state subject 5 were moved towards the central subject. Okay, and some are moved to the concurrent list, right? So, this kind of changes will definitely happen. Okay. Remember, very, very important, these kind of lists. Okay. 8th schedule, very, very important. The 22 official languages of the country are part of the 8th schedule. Okay, and this 8th schedule plays a very, very important because there is one award called as a Gnanpith Award. Gnanpith Award is the highest literary honor, and if you wanted to get Gnanpith Award, you can get in the 22 Indian languages. What are the 22 Indian languages? Those languages which are part of the 8th schedule. Those 22 languages which are part of the 8th schedule plus English. These are allowed in the Gnanpith Award. So, that 8th schedule is nothing but this one. So, the provisions relating to the 8th schedule are in Articles 344 Clause 1, 351. Okay, 22 official languages in India are covered under the 8th schedule. Very, very important. And next is nothing but 9th schedule. Very, very prominent 9th schedule. Why? Because if any acts are kept in the 9th schedule, they will not come under the judicial review. They will not come under the judicial review. For example, I will give a very, very lively example. Now, recently, the union government passed a bill called Waqf Bill. Yes or no? Now, this Waqf Bill, this act became, okay, Waqf Bill converted into Waqf Act. Now, some people went to the court to review this bill. Now Supreme Court has taken the bill for review or not? It has taken. Why? Because this Waqf amendment bill is not part of the 9th schedule. So very, very important. If something comes under the 9th schedule, it will not be under judicial review. Okay. For example, if you see that in Tamil Nadu state, the amount of reservations have crossed 65%. But still, Supreme Court is not interfering in that because that was made part of the 9th schedule. Got it? So that is the significance of the 9th schedule. Land reforms, part of the 9th schedule. So there will not be anything like a judicial review whether this bill is right or wrong. Got it? So that is the significance of the 9th schedule. Remember, very, 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 very important. The schedule contains a list of central state laws which cannot be challenged in the courts and was added to the Constitution's First Amendment Act in 1951. Remember that after the Constitution came into force on 26th January 1950, for the first time we made a Constitution amendment. In which year? Immediately next year, 1951. In that 1951, what we did, till that point of time we had only 8 schedules. We added the 9th schedule and we kept that 9th schedule because those things which are not going to be part of the judicial review will be kept under the 9th schedule. So that's the importance of that. The first amendment added 13 laws to the schedule. Subsequent amendments in various years have taken the number of protected laws to 284 currently. So 284 laws are protected under from the judicial review. So Supreme Court cannot review these laws. Okay. It was created by the new Article 318, which along with Article 31A was brought in by the government to protect laws related to agrarian reforms or for the abolishing the Zamindari system. Why? Because see, very, very important this one. Zamindari system was there. Now government has abolished the Zamindari system and said that this amount of land does not belong to you. Okay, we are taking away these lands. Then that person will go to the court and say that during that point of time Article 31 was in force. So right to property is my fundamental right. How can they take away this? They will ask. That is the reason they made abolition of Zamindari Act and they kept that in the 9th schedule and they said that if something is part of the 9th schedule, it is not coming under the judicial review. So you cannot go to the court and ask for any appeal on that. So that is the significance of the 9th schedule. Got it? Very, 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 very important. Akila Bhanotu, this is a Chandan Logic's English channel. So here we will be talking only in English. But on Saturday, on Monday, I will be coming in the Chandan Logic's general channel or main channel. There I will take both English and Telugu. Okay? And if something of this kind of trouble comes, give some patience, listen to the class. Slowly your English also will improve. Okay? Not only subject, you also get a scope to improve your English also. See, English you get only upon listening. The more you listen, the better you speak English. Okay? So, listening is the best way to learn English. Clear? When I was in my school, I was from English medium school, I was in a hostel and the attender who struggled to pass 10th class, he was speaking English fluently. The reason is that he was staying with us. Since he was staying with us 24/7, there was a strict rule in my hostel that we should speak only in English. When we speak in Telugu, we need to write assignment that I will not speak in Telugu, I will not speak in Telugu. Very big assignment, like 1,000 times we should write. So we used to speak all the butter English, but English only. Now that attender also got used to that and he started speaking English. So English is not dependent on your education, it depends on how much you are listening English. Okay? Yes. Next one. Which of the following writs is issued to prevent a person from performing an act in public office to which he is not entitled? Okay. So a person is not entitled to be in that position and is doing some work. Now the court is interfering and preventing that person because he is not eligible to sit in that position. Then what is the kind of the writ that a court will issue? That is the question. Certiorari, quo warranto, habeas corpus, prohibition. Which kind of writ is applicable to prevent a person from doing some activity in a position which is not entitled to, is not having qualification to be in that position? Okay, then what is that writ that is passed? That is the question. Yes? Yes, right to property is not fundamental right now, it is a legal right under Article 300A. That's right. Ganesh, good evening Ganesh. Yes. Okay, I am getting two answers, C and B I am getting, but the right answer is C, B, C, B, B, C, B, C, B. Okay, quo warranto is right. Quo warranto, under what authority, under what qualification you hold in that position? If a person is getting into a position without having proper authority, proper qualifications, you can challenge that position by issuing a writ called as quo warranto, what authority? Okay, very important. Now, what is a certiorari? The higher court is certifying that the judgment passed by the lower court is not right. Okay. What is the meaning of habeas corpus? Get the body of the person. For example, some of your family or relatives were kidnapped. You don't know the whereabouts of that person. You are searching, you are not finding that person. You went to the police station, police is not taking things seriously. Now go to the court and file a habeas corpus petition. Now court will call the police and ask, where is this person? The police will say, I don't know. Then what court will tell? I am issuing a habeas corpus writ. You find out that person, bring that person before me, dead or alive. If the person is dead, bring the dead body. If the person is alive, bring the live person. But that person's body should be present here. Habeas corpus means the body of the person. Okay, so that is the significance of habeas corpus. Many people, like for example, generally this will be filed by the people who are affiliated to Naxalism, because sometimes they doubt that if police has kidnapped them and did some fake encounters or something. So immediately they will go to the court and file habeas corpus, and they will get a petition or they will get a direction from the court saying that that person should be presented before me in the court. Okay, if the person is dead, they will bring the dead person. If the person is alive, they will bring the alive person. Okay, that is the significance. Prohibition, preventing the person from doing the duty which is not supposed to do. Okay, and the higher court is preventing the lower court from doing the duty. It's called prohibition. What is that called as? Prohibition. Very important. Okay, we'll see each and every one. First one, quo warranto. See here. Quo warranto is a petition through which a person is asked under what authority or power he has acted or taken a decision. To take the decision, what is the authority that you have? Are you eligible to take the decision? That is nothing but quo warranto. Okay. The purpose of this writ is to restrain a person from holding a public office which is not entitled. Means that person is not eligible to be in that office, but is doing that work by being in that office. So there is nothing but quo warranto. Okay. When a person starts acting as an officer of which he is not legally entitled to. Okay. You are not having eligibility and you went to that office. Now I will go and file a quo warranto petition. Okay. For example, I will give an example. Let us say that there was a rule earlier. What is that rule? A person who is having more than 2 children after 1996 is not eligible to become a sarpanch. Now let us say one fellow became a sarpanch like that only and is just doing his duties. Then I go and file a case that and what authority this person became a sarpanch. He is not eligible to become a sarpanch because he got 3 children after 1996. So quo warranto like that. Okay, very important. This writ prohibits a person or an officer from performing an office for which he is not authorized, and thus this writ prohibits the taking of the public office by any person. So without authority cannot get into any position. That's called as what? Quo warranto. Okay. Next one, certiorari. Certifying. Certiorari means what? Certifying. Higher court is certifying that the judgment passed by the lower court is not right. See here. Certiorari is a common law jurisdiction, a writ issued by a superior court to re-examine the action of the lower court. Certificate is also issued by an appellate court to obtain information about the case pending before it. Okay. So higher court is certifying the lower court. So there is nothing but certiorari. Next one, habeas corpus. Already told you enough on habeas corpus. So same thing. So this order can be obtained by the arrested person himself or any of his associate by pleading in the court. The principle of habeas corpus gives protection to the ordinary citizens by stopping such arbitrariness of the state. Habeas corpus mandate is an order issued by the court to the police or other arrested state body to produce the prisoner in the court and to report the charges against him to the court. Like that. Okay, very important. So if a person is illegally arrested by the police, you can go to the court and get a direction from the court to the police to present the person in front of the court. Okay, that's habeas corpus. Next one, see a prohibition. When a court employs an extraordinary measure of prohibition, it directs the conduct of a party and does so with the support of all its coercive powers. A party that fails to comply with an prohibition faces criminal or civil penalties, including possible monetary sanctions and revenue imprisonment. Okay, you are prohibiting the person from doing a duty. You are prohibiting the public officer person from doing the duty. That's called prohibition. Okay. Yes. Yes, quo warranto for government employees. Okay. Certiorari is for a higher court to lower court. Very, very important. Who was the president of the Constituent Assembly of India after independence? Very simple question. Who was the president of the Constituent Assembly of India after independence? That's the question. Yes, excellent. The right answer is superb. The right answer is Dr. Rajendra Prasad. Okay, Dr. Rajendra Prasad. So when the Constituent Assembly was formed, first meeting, Sachidananda Simha was the presiding because he was the oldest person in the hall. Later on, Dr. Rajendra Prasad was elected as the president of the Constituent Assembly. He continued as the Constituent Assembly till the end. So, answer was Dr. Rajendra Prasad. He is called as Ajata Shatru. He is called as what? Ajata Shatru. Okay. See here. And C. Rajagopalachari is the first Indian Governor General of independent India. He is the first Indian Governor General of independent India. He is also the last Governor General of India. C. Rajagopalachari. He is the first recipient of the Bharat Ratna also. He is the first recipient of Bharat Ratna also. Okay. Very, very important. Just see here. Rajendra Prasad was the first president of the India serving from 1950 to 1962. It was a lawyer, all those things, okay, fine. During Salt Satyagraha in 1930 and the Quit India campaign of 1942, British authorities imprisoned Prasad, a devotee of Mahatma Gandhi. And Prasad became Minister of Food and Agriculture, all those things in 1946, when we had something called as Viceroy's Executive Council, okay. And he was chosen as the President of the Constituent Assembly. That is the important thing. Constituent Assembly of India, which was constituted by representatives of the provincial assemblies elected by the Indian people, drafted the constitution. Okay, and the president of the Constituent Assembly for the first time was what? Sachidananda Sinha. Very, 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 very important. Okay, and later on, Dr. Rajendra Prasad was chosen as the president of the Constituent Assembly. Okay, next one. Into how many constituencies was India divided for 2019 Lok Sabha elections? Okay, in 2019 Lok Sabha elections, how many constituencies were there in India? Parliament constituencies. That's the question. Okay, guys. Hi, Macha. Anjali Anju, good evening. Yes, 543, 342, 345, 247. What is the answer? Excellent. 543 is the right answer. If you go to the Lok Sabha, total number of seats are how much? 543 seats are there. Yes or no? This will increase in future. Why? Because now they are going to have one more census. After this census, there is a proposal to increase the number of seats, and there is a lot of criticism from the South Indian states because North Indian number of MPs will increase compared to South India's number of MPs. Okay. See here, very, very important. For the purpose of the constituting the Lok Sabha, the whole country has been divided into 543 constituencies. Okay. Meanwhile, I want you to comment one thing. Earlier, Anglo-Indians were also have nominated to the Lok Sabha, but now Anglo-Indians are not nominated to Lok Sabha. Which constitution amendment was brought to prevent the Anglo-Indians nomination to Lok Sabha? So, tell me that answer. Which Constitution Amendment Act was brought to prevent the nomination of the Anglo-Indians to the Lok Sabha? Very, very important question, that one. The members of the Lok Sabha elected directly. We know that January 2020, the Anglo-Indian reserved seats in the Parliament and State Legislature of India were abolished by the 104th Constitution Amendment Act. Very, 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 very important. Till that point of time, in the assemblies and in parliaments, Anglo-Indians had a representation. But after 104th Constitution Amendment Act, which was brought in 2020, now this representation is not there. Why? Because when British left India, some people of British stayed back in India. Now these people will be very, very small number. when there is no representation for them because they cannot get elected very easily. So that is the reason they made a provision that there will be some nominated members of the Anglo-Indians also. But now that has been removed. Very, very important. Okay. 131 seats are reserved for representatives of scheduled caste and scheduled tribes in Lok Sabha. Out of 543 seats, 131 are reserved for what? Scheduled caste and scheduled tribes. This is also very, very important. Okay. Remember that in Lok Sabha, there is no reservation for the backward communities. There is reservation only for scheduled caste and scheduled tribes. Now we are going to have a reservation for women, but it happens only after the next census happens. Okay. Very, very important. The first elected parliament of the independent India came into existence in which year? In which year do we have the first elected parliament of the independent India? 1949, 1947, 1951, 1952. What is the answer for this question? Guys, first elected parliament came into existence. Learner, try to answer this question. Okay, I got the first answer from Vijay Devarkonda. That's nice. Right answer is 1952. Okay. So after the first general election that happened in the country, we got the first parliament into existence and with Jawaharlal Nehru as the prime minister of the country. Okay. Before that also Jawaharlal Nehru was the prime minister. After 1950 elections also Jawaharlal Nehru was the prime minister. See here, the first Lok Sabha was constituted on 17th April 1952 after the India's first general election. Okay. And this was dissolved on 4th April 1957 after 5 years. Okay. The first session of this Lok Sabha began on 13th May 1952. So on 17th April it was elected and first session happened on 13th May 1952. So the answer is what? 1952 is the right answer. From there onwards we have got elections and also elected representatives in the country. Since head of the country, the president is elected by the people, because the people who are elected by the people are again electing the president, so India becomes a republic country. That is also very, very important. Next question here, very, very important. In a parliamentary system, the legislative, judicial and emergency powers are in reality used by the president only on the advice of the... Okay. So simply they are asking, the president acts on the advice of Council of Ministers, Chief Ministers, Members of the Parliament, Vice President. Okay, very, 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 very important. Yes. First speaker is Maulanka, that is right, learner. You're right, Amma. Guys, what's the answer? Superb, superb. Lokesh, Rishita, everyone is coming with the right answer, Andy. The right answer is nothing but Council of Ministers, right? So here if you see that makes the president a nominal head, is not the real head. Council of Ministers headed by the Prime Minister will be advising the president, and president has to act upon the advice of the Council of Ministers, which is headed by the Prime Minister. That's a very, very important provision. Okay. So if you see here, so Council of Ministers under the leadership of the Prime Minister will be advising the President. Very, very important. Okay, good. One second. Yeah. Yes. Clear? Yes, Article 7 and advice of, that's nice, Anu, excellent. Article 7 is very. So, and one more important thing, the Council of Ministers and other ministers are responsible to the Parliament. It is under which article? Under which article the ministers and the Council of Ministers are responsible, Council of Ministers are responsible, or Council of Ministers are collectively responsible to the Parliament? Under which article? Try to answer this question. Very, 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 very important. The Council of Ministers are collectively responsible to the Parliament. Under which article? So try to answer this question. Let me see. How many ministers can be included in the Council of Ministers of the Union? Okay. 10 to 15% of the total number of the members of the House of the People, 50% of the total number of the members of the House of the People, as many as wished by the Prime Minister of India, 15% of the total number of the members of the House of the People. When I say House of the People, I refer to Lok Sabha. I refer to what? Lok Sabha. So, I am telling everywhere about Lok Sabha. So, based on the strength of the Lok Sabha, how much percentage of people can become the Council of Ministers is a question. Sharana, very good evening. It started at 7:30 Amma. It's been 40 minutes. Okay. So, for the question that I already asked, the answer is Article 75 Clause 3. Under Article 75 Clause 3, the Council of Ministers are collectively responsible to the Parliament. Collectively responsible to the Parliament means when they don't enjoy the support of the Parliament, they have to resign completely. Not one person cannot resign, all should resign under Article 75 Clause 3. Okay. Now, what's the answer for this question? Superb, excellent, excellent. 15% is the right answer. 15% of the strength of the Lok Sabha. So, 15% of the strength of the Lok Sabha only can become the Council of Ministers, not beyond that. Why this condition was kept? This condition was kept to prevent the horse trading of the elected representatives. Because when there is no limitation, the ruling party can influence the opposition party member saying that you come and join us, we'll give you a minister. They can give as many number of ministers that they want if there is no restriction. That is the reason they kept a restriction of how much? 15% of the total strength of the Lok Sabha, not Rajya Sabha. Very, very important. But the ministers can be from Lok Sabha or Rajya Sabha. Ministers can be from Lok Sabha or Rajya Sabha. A person who is not member of Lok Sabha and Rajya Sabha can also become a minister, provided that within 6 months he should become the member of any one of the house. Okay? These are important things. Yes, they are included, Lokesh. They are included, Lokesh. They are included. Okay? I hope there is a streaming happening, right? Yes. Yes. Included name is 15%. Prime Minister and ministers are collectively known as the Council of Ministers. There are 3 categories: ministers of cabinet ministers, ministers of state, deputy ministers. See, I'll tell you how this is. These complete ministers, okay, there is something called cabinet ministers. What are they called as? Cabinet ministers. Beyond that, there are 2, okay. Some ministers, they are called as a Minister of State. Minister of State will be the helping ministers for the cabinet ministers. They are like deputy to cabinet ministers. Okay. There are some more person, Minister of State, independent charge. Independent charge means what? They are not under anyone. They are not under it. They are not deputy to anyone. They are working independently. Minister of State, independent charge. Okay, that's the meaning. Okay, remember this is the difference. For example, you take Bandi Sanjay. Bandi Sanjay Garu is the deputy minister or minister of state home. Means what? He is assistant minister for whom? For Amit Shah, who is a cabinet minister. Who is a cabinet minister, like that. So like that. So there are some other ministries, they are having independent portfolios. They are not under anyone. Okay, Minister of Planning and Statistics, Rao Indrajit Singh, maybe Minister of State, independent charge, like that. K. Ramohan Naidu is a cabinet minister. He is a cabinet minister. Under him, there will be some deputy ministers also. So, very important. Clear? Next one. The first High Court of India was established in. The first High Court of India was established in Kolkata, Delhi, Mumbai, Punjab. What is the right answer? When was the first High Court in India established? That's the question. Yes, guys. Jadhav Pratap, yes. Quick, guys, quick answer questions. Super, excellent. The right answer is nothing but Kolkata is the right answer. Okay. So the first High Court in India was established in Kolkata. Very important. It was formerly called as the High Court of the Judicature at Fort William. Okay. It was established in Kolkata, which year under High Court Act of 1861 it was established. Okay. It was formally opened on 1st July 1862. Okay. Sir Bernice Peacock as his first Chief Justice of the Calcutta High Court. Who is that? Bernice Peacock is the first Chief Justice of the Calcutta High Court. And Justice Sumbhonath Pandit was the first Indian to assume office as the Judge of the Calcutta High Court. So, the first High Court in India is what? Calcutta High Court. Very, very, very important. When was it opened? 1862. Under which Act? Under 1861 Indian High Courts Acts. Okay, very important. Next one. The first amendment to the Constitution of India was made on, very, very important, already we discussed, 1951, 1953, 1952, 1950. What is the right answer? First amendment to the Constitution. I told you that 9th schedule was added under the first amendment of the Constitution. So, in which year was this amendment made? 1951, 1953, 1952, 1950. Okay, guys, quick. Yes, Bernice Peacock. Excellent, excellent. The right answer is nothing but 1951. I told you that Constitution came into force in 1950 and the first amendment to the Constitution was made in 1951 by adding the 9th schedule of the Constitution. So, the first amendment was made in 1951. The first amendment added the 9th schedule to the Indian Constitution. Here, very, very important. It restricted the freedom of speech and expression. Okay, why? Because you cannot say that this is my property. Okay. It was introduced to remove certain practical difficulties created by the court's decision in several cases such as Kameshwar Singh case and Romesh Thapar case, all those things. Okay. The first amendment protects us against the government limits on our freedom of expression, but it does not prevent a private employer from setting out its own rules. It prevents the government from requiring you to say something you don't want to or all these things. It also insert Article 31A and 31B into the Indian Constitution. Okay. Next one. Very, very important. 9th schedule we already discussed in detail, right? Yes. Which of the following states has the legislative council? Nice question. Himachal Pradesh, Assam, Andhra Pradesh, Madhya Pradesh. Only one among these four has got legislative council, which is nothing but example of bicameralism. You know that we have got something called bicameralism. Bicameralism means having the two houses. At central level, we have got Lok Sabha and Rajya Sabha. At state level, there are some states where there is a legislative assembly, legislative council also. Now, I am asking, out of the states which are mentioned here, which state has got that legislative council? That is my question. Is that clear, guys? New CJ BR Gawai. Okay, good. Excellent. Andhra Pradesh. What is that? Andhra Pradesh. There are total 6 states which have got this legislative council, bicameralism at the state level. Now, how do you remember that? Very simple logic, I'll tell you. See here. First of all, see here. Uttar Pradesh is there. Okay. And Bihar is there. Both of them are side by side. So, if you look into Indian map, if you see, here Bihar, beside Bihar you got Uttar Pradesh. Clear? So, this is very clear. Next see, Karnataka and Maharashtra. So, this is Maharashtra, attached Karnataka. Okay. Andhra Pradesh and Telangana. So, this is Telangana, this is Andhra Pradesh. This is Telangana, this is Andhra Pradesh. Okay. So, these two joining states and see that always there is a disputes. Maharashtra, Karnataka, there are some regions where Karnataka claims that it should be part of Karnataka and there are some Maharashtra also claims that it should be part of Maharashtra. When you come to Telangana and Andhra Pradesh also, with respect to Bhadrachalam, there is also again dispute. Earlier Telangana was separate, again they added some 6 mandals into Andhra Pradesh. So, like that. Okay. So, Uttar Pradesh, Bihar. Maharashtra, Karnataka, Telangana, Andhra Pradesh. So, these are the 6 states. Very, very important. Okay. And the size of the legislative council may vary, but its membership should not be more than 1/3 of the assembly. For example, if there are, let's say, 100 members in the assembly, the member of the legislative council cannot be more than 30, cannot be more than 33. Okay. So, like that. So, every time it should be 1/3 of the total members of the legislative assembly. So obviously Uttar Pradesh has got more number of people, so the legislative council also will be very, very big. Telangana has got only 117 members, so 119 members. So obviously what will happen, only 1/3 of, means 120 lo by 3 years 40, means the member of legislative council cannot be more than 40 members. So like that, okay. Where is the headquarters of the International Court of Justice located? Very simple question. Hague, Paris, Washington DC, New York. What is the answer for this question? Article 116, abolition and creation, exactly. Hi Tony, very good evening. Very good, very good. The Hague is right answer, but my question is, who is currently the Chief Justice of International Court of Justice? Try to answer this question. Who is currently the Chief Justice or President of the International Court of Justice? Okay. So the Hague is the headquarters for ICJ, International Court of Justice. Not only ICJ, the Hague, Netherlands, we have got ICC, we have also got OPCW. All these are headquartered in the Hague, Netherlands. The Hague is called as judicial capital of the world. What is it called as? Judicial capital of the world. Judicial capital of the world. The Hague is called as the judicial capital of the world. Very, 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 very important. Okay. Yeah, Lokesh, me kosame a question adiganu. Okay. Nawab Salam is no more the president of ICJ. He is gone. Currently, the president of ICJ is Yuji Iwasawa. Yuji Iwasawa. So recently there is a change. Everyone should note the currently the president of International Court of Justice is Yuji Iwasawa. So Nawab Salam is no more the president of ICJ. Very, 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 very important. ప్రతి ఒక్క నోట్ చేసుకోండి, కరెక్షన్ చేసుకోండి, అవునా? ఓకే. 15 judges 9 years, చీఫ్ జడ్జ్ 3 years, you are right. ఓకే. ICC అంటే వేరే అమ్మా లోకేష్. ICC stands for International Criminal Court. Criminal Court. What you are talking is the International Cricket Council. అది దుబాయ్లో ఉంది, అది ఓకే. ఇది ఇంటర్నేషనల్ క్రిమినల్ కోర్ట్. ఓకే. వెరీ, వెరీ ఇంపార్టెంట్. ఓకే. యూజీ ఇవసావా రీసెంట్గా చేంజ్ అయింది టోనీ. ఓకేనా? Actually Nawab Salam was the Lebanon, he is from Lebanon, but now he became the Prime Minister of Lebanon. So as he became the Prime Minister of Lebanon, he resigned for this and went there, and Yuji Iwasawa from Japan got elected as the President of ICJ. Okay, make a note of this, all of you, so that you will not miss it out. Okay na? Yes. Clear guys? And Paris is the headquarters for lot of things and UNESCO akkade undi. International Energy Agency akkade undi. OECD akkade undi. Avuna? FATF akkade undi. Ivanni kuda manaki ekkada unnai? Paris lone unnai. Washington DC lo manaku World Bank undi. Ade vidhanga IMF kuda undi. World Bank, IMF. న్యూయార్క్లో మనకు యునైటెడ్ నేషన్స్ జనరల్ అసెంబ్లీ ఉంది, ఆర్ యుఎన్ఓ అక్కడే ఉంది, న్యూయార్క్లో ఉంది. యుఎన్డిపి కూడా న్యూయార్క్లోనే ఉంది. యుఎన్డిపి కూడా మనకు న్యూయార్క్లోనే ఉంది. రైట్? సో ఆల్ దీస్ ఆర్ ఇంపార్టెంట్. క్లియర్ గైస్? ఎస్. In the Indian Constitution, from which country were the concepts of liberty, equality and fraternity adopted? Okay. భారత రాజ్యాంగంలో ఉన్నటువంటి తెలుగు. In the Indian Constitution, from which country are the concepts of liberty, equality and fraternity are taken? Japan, France, USSR, Britain. What's the answer? Quick guys. Yuji Iwasawa. Exactly, Sharanya. You're right. Superb. Excellent, excellent. The right answer is France. Right answer is what? France. Okay. Let's look into this. Okay. So can you tell me something about other things? Okay. Britain. Okay. From Britain also we have taken some features. From USSR also we have taken some features. Okay. What is that feature called as fundamental duties? Fundamental duties. Okay. Fundamental rights come from USA. Fundamental rights come from DPSPs come from Ireland. DPSPs come from Ireland, right? There is a huge list of this. Huge list of this. Yes. Very good. Very good. Very good. Excellent. Okay, lot of things are there. NITI in NITI Aayog stands for what? National Index of Transcending, yes. Emergency from Germany. Okay. National Index of Transcending India, National Institute of Transforming India, National Institution for Tracking Indians, National Institution for Transforming India. What is the answer? So what does NITI stands for? NITI Aayog lo NITI. What does NITI stands for? Guys, Federal System Canada, that's right, learner. Duties Russia, concurrent list Australia, dietary principles Ireland. Superb, superb, excellent, excellent, excellent. Don't get confused. Exact word you should get, man. You should get exact word. Rajiv Gauba as a full-time member of NITI Aayog, exactly. And Rajiv Gauba served as the Cabinet Secretary of India. He served as what? Cabinet Secretary of India, Rajiv Gauba. Very important. Okay, very good, very good. So right answer is option D is right. National Institution for Transforming India. It came into existence on 1st of January 2015. Okay. And remember that NITI Aayog is a non-constitutional, non-statutory body, non-constitutional, non-statutory body. It is just a policy think tank. Policy think tank. And remember that the ex officio chairperson of the NITI Aayog is the Prime Minister. Prime Minister is the ex officio chairperson. And currently we have got Vice Chairman as Suman Beri. Suman Beri also has got additional responsibility as the Chairman of the Economic Advisory Council to the Prime Minister. He has got additional responsibility as the Chairman of the Economic Advisory Council to the Prime Minister. And currently if you see CEO is BVR Subramaniam. His term got extended recently. BVR Subramaniam is the current Chief Executive Officer of NITI Aayog. Clear? Yes. Which part of the Indian Constitution deals with the fundamental rights? So fundamentals are dealt in part 9 or part 6 or part 11 or part 3. Very easy, very simple, straight question. Okay. 1 year extended, Anu, you're right. Yes. What is the answer for this question? Superb. Excellent. Okay. Part 3 of the Constitution deals with what? Deals with the fundamental rights, which are borrowed from a USA Constitution. Fundamental rights. Fundamental rights are justiciable in nature. Fundamental rights are justiciable in nature. That's also very important. They are justiciable in nature. Fundamental rights. Okay. Because when your fundamental rights are violated, you can approach the court and get your fundamental rights enforced. Okay. That's important. Okay. Yes. Part 3 is right answer. Superb. Part 4 DPSP, that's right. Part 4A fundamental duties, that's also right. Yeah. See this question, very important. Under the provisions of the which article of the Indian Constitution is the President empowered to constitute a finance commission at the expiry of every 5th year or at such earlier time as the President considers necessary? Article 282, Article 280, Article 283, Article 281. What's the answer? So under which article can the President constitute Finance Commission? What is the article that is related to the Finance Commission? That is the question here. Okay, guys. Hey, macha, think again, macha. Tony says Article 280. Okay, excellent. The right answer is under Article 280 of the Constitution. As per Article 280 of the Constitution, the President can constitute a Finance Commission. Okay. Now, currently what we have is nothing but 16th Finance Commission. What we have is a 16th Finance Commission. Okay. The period of the 16th Finance Commission goes from 2026 to 2031. 2026 to 2031. And currently the 16th Finance Commission Chairman is Aravind Panagaria. Aravind Panagaria. Aravind Panagaria is the Chairman of the 16th Finance Commission. Who is that? Aravind Panagaria is the Chairman of the 16th Finance Commission. Very, 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 very important. Okay. And earlier we had a 15th Finance Commission, but the 15th Finance Commission time period is from 2020 to 2026. Means how many years? 6 years. N.K. Singh was the chairman. So there is no hard and fast rule that Finance Commission will be exactly for 5 years. It need not be. Sometimes the term can lessen or become less, or term can also increase. Both the things can happen. Okay? Yes. So under RRB ALP 2025, we got special batch for CBT 1, 3, 6 and 12 months duration. You can make use of this. And RRB ALP 2025 special batch is there for 900,900 plus vacancies, which is a complete course for 6 and 12 months duration. And RRB Group D 2025 special batch is there with 32,430 plus vacancies, 3 and 6 months duration. And then RRB NTPC 2025 special batch is there with CBT 1, CBT batch course available, 3 and 6 months duration. Okay. And SSC CGL 2025 special batch is available, 600 plus hours video structure is available, class available both English and Telugu, and we have got 3 and 6 months duration for Tier 1 and Tier 2. And SSC exam 2025 special batch, 550 plus hours of training, and then 3, 6 and 12 months duration available both English and Telugu medium. And Bank plus SSC plus RRB is also available for 6 and 12 months duration, 850 plus hours of training is available here. So English and Telugu medium both available. Bank Mahapack for all banking related examinations, it's English medium and bilingual, okay, and 6 and 12 months duration. And APPSC Tspsc Group 2 course are also available, and then SA Constable course are also available for 3, 6 and 12 months duration. And APPSC and TSPSC state exams, all things are taken care here. And then UPSC CSAT is also available for 2 and 6 months durations. And 0 to 0 special batch is also available for arithmetic, reasoning and advanced maths. And you can pick up any course for just for only 999 only. Clear? That's it from my end for today. Guys, yes, next my class will be on day after tomorrow. That also will be on English channel only. That's on Friday. Okay, and then Saturday we'll have come to the other channel. Okay, but English channel, my class will be on Friday, day after tomorrow. Okay, thank you guys. Okay, yeah, see you, bye bye. Here I'll have Friday and Saturday next classes. Okay, see you all, bye bye, take care. Signing off, this is your Naras sir. Bye.